Moving on to our first panel of the day on Save the Data, Localization as Democratization. This discussion will unpack why arguments for localizing data persist in spite of the benefits countries have reaped from the free flow of data. Please welcome our speakers, Melinda Claybaugh, Privacy Policy Director, Legislation, Meta; Ralf Sauer, Deputy Head, DG Justice and Consumers Unit for International Data Flows and Protection, European Commission; Audrey Blanc, Head of Division, Digital Economy Policy, the Organization of Economic Cooperation and Development, who will be joining us virtually; Rahul Mathan, Partner, Trilegal. The panel will be moderated by Anirudh Burman, Associate Research Director and Fellow, Carnegie India.
Good morning, everyone, and welcome to this discussion on data localization. I think Minister Teo's address very neatly encapsulated the benefits and the approaches to free flow of data, and I think it provides a good introduction to the discussion we are going to have. Now, very briefly, data localization is about imposing some kind of restriction on the cross-border transfer or flow of data. And there have been many arguments made about why it's necessary in certain contexts. And in India, we've had our own set of discussions and debates about what motivates this and how appropriate it is to impose localization requirements. 2 weeks ago, we've had a new draft of a draft personal data protection bill that takes a significantly different approach to localization from the previous iterations. So I want to start with Rahul and ask him, what do you make of this change? What do you read in the bill about the government's approach? Because it's also a little ambiguous. And especially, how is it different from the previous versions?
Thanks. I sort of feel for Carnegie because the program was decided before the bill came out, and to my reading, the bill completely reverses the idea that was started by the Justice Sri Krishna draft around localization. And I say this because if you look at the evolution of the law since the first draft to its current stage, we've seen a steady whittling away of the localization imperative that started in the Justice Sri Krishna draft. That was a localization of personal data. The next draft had a localization only of sensitive personal data. And this draft actually doesn't even use the word localization. It says that transfers will be permitted to certain named countries that are presented in the schedule. And if I look at the trend, I would say that this is we've reached a position where virtually there is no localization, that the government is now going to move to an approach where it is going to identify certain countries to whom data may not be allowed to be transferred. And we're still to see that list of countries. But it's not an obligation to keep data here. It is more an obligation not to share data with certain named countries. And I think there is still a lot to unpack because there is a provision in terms of what conditions there are that may be prescribed with regard to which countries will be on the list or not, and so that's a level of detail that we need to unpack. But I think it would be remiss on our part as the panel to ignore what has happened since the Justice Sri Krishna draft, which is The moment the draft law was made public, the Reserve Bank of India introduced a payment localization obligation. We've seen similar sectoral localization obligations coming up in various other sectors. And so I think the question that we will perhaps need to continue to ask ourselves, despite what this draft says, and if this draft does get enacted, what the law says, is that sectoral restrictions on where data can be kept may still be a factor that we have to contend with, particularly since most financial institutions have already complied with the RBI payment mandate. It seems unlikely that having complied with what was at the time a very difficult engineering lift, that they're going to now easily unwind it. And so there is that factor that we also need to consider. But to answer a specific question, I think if Carnegie had maybe a few more weeks' notice, we may not be sitting here, or we may be sitting here discussing something completely different.
That's a very optimistic assessment of the bill. Just to push you a little bit on that, because there is scope for imposing terms and conditions for transfers within the bill that the government has reserved for itself. So it's not going to be a pure whitelisting process. There might be additional requirements that are imposed. Do you think that there is scope for that?
I mean, I read it more as terms and conditions that may be prescribed for how countries get onto the whitelist. And that would be very different from the terms and conditions that would be imposed in order, even though you're on the whitelist, to still transfer data. Now, and I'm sure Ralf will come in a lot more detail on this, this is not the way Europe, and as we heard, Singapore does this. And I think there is merit in considering just this whole concept that Europe came up with, which is adequacy, considering how do we ensure that the protections that we give to our data, the data of people in India, is adequately reflected in the countries to whom that data is transferred. There is certainly merit in considering that. But my view, and Ralf and I have had the benefit of a long conversation over breakfast, so I'm going to paraphrase briefly, is that India is where Europe was in the 1980s. India has no experience of data protection. And so I think we need to get our internal house in order first, our domestic house in order first. And we've got to build the nuts and bolts and the pipes and the plumbing for us to be able to do this right. And then after that, I think we can certainly graduate to these considerations of adequacy and things like that. So personally, I think the approach, which is quite frankly no different from the approach that exists up until now, because we have no law and therefore we have no restrictions, to let it lie for a little while. We have a law but still no restrictions, and then graduate into trying to impose perhaps some sort of barrier such that when we've protected our data to a certain level, we don't, through transfers, affect the data protection that individuals are accustomed to in India. But I think we need to grow into it, and I think that would be the sensible, measured approach given the current state of our data protection jurisprudence.
Thanks for that, and I think we'll come back to this question of a whitelist and a trusted geography that's been going around in our second round of questions. I'm tempted to go to Ralf, since Rahul's mentioned some potential disagreement between the two of them, but let me turn to Melinda first and ask you for your views on the bill, and also, does it solve some of your apprehensions or issues with the previous versions of the bill?
Thanks. Okay. So I think on a larger level, in terms of this draft of the bill itself, I think we've seen a lot of really positive developments. Specifically, I think this draft of the bill is focuses on a principles-based approach to data protection without being overly prescriptive. And so there is a kind of streamlining of concepts, particularly around the definition of personal data and kind of the removal of some of the categories of critical personal data, non-personal data, which were very unclear in prior drafts, and more aligns this draft framework with other international standards. I think we've also seen a really helpful introduction of explanatory, examples in the text of the law, which provides a lot of guidance. And so I think that kind of simplifying the draft a bit to a principles-based approach leaves appropriate room for developing more specificity through secondary regulation, which hopefully will be done through a very consultative process as well, and providing that flexibility for future technological and innovative developments. With regard to the data localization provisions in particular, I obviously think, agree with Raul that this is a very positive development in terms of removing the local storage mandates. And I think there are a lot of questions that still need to be resolved around what this whitelisting approach would look like. I think we need to keep in mind that it will be important for businesses to have certainty about where the data will be able to flow, and will be able to have that certainty sufficiently in advance of being expected to comply with the requirements of the law. What's really important here is making sure that the data is allowed to flow now. So any restrictions we place on that ability to have data transfer internationally need to be very carefully considered, made in a very transparent and clear way, with sufficient notice to businesses. And we can maybe talk a little bit more later about what those criteria for whitelisting would include.
Thank you. And before I move on, I just wanted you to quickly give a sense to the audience about what is at stake when you impose localization requirements. How does it affect the business model of a company like Meta, but also any startup, any small business that's basically storing data abroad or sending it abroad for analytics and so on?
Yeah, I mean, I think we all kind of inherently understand in our daily lives as consumers that we are interacting with businesses around the world and using services kind of globally, and in our daily lives of kind of making travel reservations or buying things from companies overseas. We are engaging in kind of the global economy. And I think we understand that on a very intuitive level. And so what is at stake here is the ability to be able to continue to do that in as seamless and as frictionless a way as we currently do. So very specifically, for companies to have to kind of store data locally, not only is it a huge kind of cost, which is a much harder hurdle for smaller companies. There are real technological challenges in terms of being able to provide seamless, real-time services in a consistent way globally. You run into challenges of kind of latency and copies, and real friction is added to the system if it's even able to still operate globally, depending on kind of the extent of localization and local storage that we're talking about.
Right. In some sense, it's the idea of sovereignty hitting up against the idea of business efficiencies, and we're just trying to figure out a good way to resolve that.
Yeah, I mean, just on the sovereignty point, I mean, I think that I think everyone agrees that there is a lot of value to be extracted from data, and particularly value for public interest and public policy making purposes. I mentioned earlier that the prior draft included this concept of non-personal data with the idea that value can be harnessed from that data. And I absolutely agree. And I think that there are privacy protective ways to take and leverage data in different ways for public interest purposes. But data does not need to be stored locally to achieve those goals. And so I think, I still do welcome a conversation maybe outside now, I guess, the scope of the bill around how to leverage personal data and non-personal data for those public goods purposes. But that's a different conversation.
Thank you. Ralf, if I can come to you now, what do you make of the bill, and especially from your vantage point, with the GDPR that has a very different formulation on adequacy, what do you make of this bill?
So first of all, it works. Thank you very much. I think it's it's an interesting bill that shows a number of commonalities with what we have in Europe. Not in the maybe level of detail, that's for sure. But I think there are commonalities on some core principles, obligations, data breach notification. Just to one example, some of the essential rights that are in the bill. Existence of a transfer regime, and we'll get to that in a second, and an independent authority that is going to supervise that. So I think those are core elements of data protection law also in Europe. Also perhaps the in principle horizontal application to the private and public sector, although I think I would also have maybe some question marks around the possibility to then exempt the public sector. But so I think there's a lot to build on. Obviously, there's also a lot that's left to further sub-legislation. So it's not always, I find, easy to judge that bill or to assess it, to get a view on it, because you simply don't know the details yet and what is going to come. I think there's also maybe some provisions or parts of the bill where more clarity could be added. So where I certainly, but I mean, have looked at this for some time now, but certainly not at the level of detail that it probably deserves. So, but I think I have some questions around certain parts of the bill, and then there are probably also some question marks or perhaps concerns that it would have, but some of it might be related to unclarity, or there might actually be things which are of concern. I think when it comes to the principles, I don't see a clear purpose limitation principle there, which I would think is a core element of a data protection law. We had indeed this earlier conversation, and I was told that it's strict purpose limitation, so you have to stick to the, which for us would mean you stick to the purpose of collection. That of course would be a strict form of purpose limitation, but I didn't see it that clearly spelled out. I think on data retention, I have some question marks when it comes to the exceptions to that. So for legal and business purposes, which seems to sort of swallow the retention principle that is in principle there. Transparency, it's only for consent, so not for all the other grounds for processing, which are called deemed consent. And there's also not a lot, actually, because it's only about, I think, the type of data and the purpose of processing, so not much more information is given. And if you then see also the right to access, also there, on demand, on request, you wouldn't get much more, I think, because it speaks about a summary of some core information. I don't know exactly what it will be, but so I think individuals to have some autonomy over the use of their data and some control, I think, deserve to know perhaps more about what's happening to their data. So that's perhaps another point. On deemed consent, and leaving aside, we had also a discussion about that, about sort of whether it's a fortunate term. I mean, we have, of course, other grounds for processing in our data protection law than just consent. I personally even have some doubts about whether consent is the best ground for processing, given how difficult it is to provide individuals with good information and to ensure that they really freely consent and don't do it because they are sort of pressured because they want to just get to that web page or use that service. So we fully recognize that there are other grounds for processing, but then there are some which at least I would have some question marks around. For instance, the one on which I think is called voluntary disclosure. So that's another point perhaps. I've already mentioned the right to access. There's nothing on automated decision making. I know this is something which you also don't find in certain other data protection laws, but I think it's something which is increasingly recognized when it comes to the use of algorithms. We have this only for completely automized decisions. So on a loan or on housing, on access to a university or something. I think if you look at the AI principles that the OECD has developed and which have also been sort of endorsed by the G20, there's something on explainability and contestability of purely automated decisions. So I think that's also something might come in another law. No, I mean perhaps it's not for the data protection law, so it might be in AI legislation that's yet to come. Just to mention that, and around the authority. I think there it's maybe a question of what will be in the sub-legislation in terms of the guarantees for independence. There's not a lot said now in the bill. And we also had a conversation on are the powers restricted to the handling of complaints? Is it all complaint driven, or is there ex officio enforcement, which I think is crucial, and I assume that's what it's meant. It should also be possible, but it's maybe not so clear from the law. On transfers, which was the starting point, I mean, we have now heard whitelist and blacklist. I think at least from the wording of Section 17, it reads like a whitelist to me, because it's you may notify countries to which you may transfer. It's perhaps the question, what is the default? So is it a prohibition and with a possibility to allow the transfer to certain specific countries? Then of course, depending on how quickly this goes, for some time there will be, in a way, I mean, it's not a full localization provision, of course, but it means that it then cannot go to all these other countries. And then, of course, there's a question of what's the standard going to be for such, if it's a whitelist, what's the standard? What are the conditions to be imposed? And are they uniform, or is this then country by country? Is it a political decision? Is it a legal decision? Indeed, and in our system, adequacy, which is sort of our corresponding provision, is about making sure that there is a comparable level of protection, because that then, in our system, allows data to go to that third country as if it was within the European Union. It really assimilates the third country to a part of the European Union, to the EU internal market, but because of that, there is a rather demanding standard for an adequacy finding. So that will be certainly a question. And I do think that an international transfer regime is a necessary element of a data protection law. If you only regulate data protection domestically, I think in a world where data indeed easily moves across borders and where companies can bring it to other jurisdictions to process it there, I think there is, I mean, one needs to think about what happens then and how do you ensure continuity of protection. So those are maybe some open questions. This being said, I mean the EU is one of the economic blocs that has clearly positioned itself against data localization. It's actually part of our trade sort of approach to free trade agreements. We have a provision that spells out various forms of localization, which we believe cover sort of all the ones that are relevant, and which we seek to prohibit. So I think it's indeed, we also see it as a step forward that there is no longer this express localization requirement, but with some questions around sort of what is the new regime.
Thank you for that. But let me pick on one particular aspect of your comments, which is about the lack of detail, and I have some sympathy for the level of ambiguity in the provision. But let me give you my sense of the flip side. The GDPR has a well laid out requirement on adequacy protection, 3 or 4 clear grounds. And one of the consequences of that has been that European courts have been using that to strike down agreements with your transatlantic partners, right? So doesn't it sometimes create more regulatory uncertainty to have that level of clarity in the parent law And it might actually be a good thing to have some level of nimbleness and flexibility in the Indian bill.
But I find this a curious question. I mean, if you believe in what our court was trying to do, I mean, first of all, it has only struck down one specific adequacy finding. It has done that twice, but it has done it for sort of the same set of questions with respect to one country. I mean, you might disagree with the focus on the question of what happens to data when it has been transferred and then is accessed by public authorities in the third country. It takes an expansive view indeed on sort of what is the continuity of protection and how far do you have to protect the data. So not just from possible abuse or mishandling by the receiving company, but also possible interference with those protections by the company, by the public sector in the third country. So, I mean, you might disagree on that, and I grant you that. But if you believe in that, then I don't know what. I mean, I cannot criticize a court for then looking into that, and if it thinks that we as the government have not done our job properly in that regard, then it has to invalidate such a decision, because that decision, as I said, means that data can go to that third country as if it was going between, I don't know, from Germany to France. So we completely trust into, I mean, or we built on the regime of a third country. There is no application of our own rules in this regard. We don't rely on the responsibility of, I don't know, a controller in Europe to ensure what happens to the data abroad. No, we completely trust in that there are good data protection rules, that there is enforcement, and that there is no disproportionate government access. Because, I mean, the point of the court was also not that government access or government interference in the third country is per se a problem. I mean, of course, we have public interest interference, if you want to call that, by the public sector as well. I mean, because there are tons of legitimate reasons for doing that. Criminal law enforcement, national security are just some, and then there's regulatory purposes. So that's not the issue. What the court focused on is, are there sufficient safeguards around that and redress possibilities, in particular for foreigners. And in that case, the regime, in the view of our court, did not ensure that, and particularly when it comes to redress, did not ensure that for foreigners, because that was essentially limited to citizens. I think we have fixed this now, and I think we will hopefully then, going forward, have again a stable adequacy finding also in that regard. But so, I mean, you might not believe or share the underlying premise, but if you do, then I don't think there's anything problematic with what the court did.
Right. Thank you, Ralf. And let me now turn to Audrey. And Audrey, thank you for joining us at 5 in the morning your time and for participating in this discussion. You've been doing a lot of work at the OECD on data transfers. So could you speak to some of the work that you've been doing, and also from that vantage point, how do you look at the new bill in India?
Yeah, so thank you for accommodating me virtually. I'm sorry to not be with you in Delhi as was intended. So yes, as you say, we've been doing quite a lot of work, well, really for the last 40 years on privacy at the OECD, starting with the privacy guidelines, but more recently in cooperation with our trade colleagues, looking at how transfer regimes are, or we're looking at commonalities between data transfer regimes across OECD countries in particular, but more broadly across different systems, whether they're unilateral transfer mechanisms, which we think of as imposed by a single party, or they're multilateral, things like the CBPRs that were mentioned earlier, or whether they're sort of principle-based approaches like the OECD guidelines. So we've mapped those out. There's a fairly well understood taxonomy around those different transfer mechanisms, and in addition, a couple other work streams that are probably of interest. One is on data localization more specifically as it relates to the privacy guidelines of the OECD, which we are regularly updating and providing evidence behind in order to help countries implement them. And I'll just sidebar to say that I think many of the principles in the guidelines are reflected in the draft bill, which of course on our side deserves a much more thorough study, and it's come sort of right before the meeting, as you said at the beginning. And then I think there's some things where, as Ralf and others have pointed out, we're interested in learning more about what is intended behind some of the concepts and the principles there. But we do see a much commonality, at least between the concepts and the privacy guidelines of the OECD and the draft bill. We've also been doing work and we'll be announcing shortly on the issue you were just speaking about on access by public authorities or by certain types of authorities to data once it's transferred or when it's moved across borders. It's what we call our government access work, and we've developed a set of principles which we're excited to be able to make public in the next couple of weeks at a ministerial meeting that we're having in Spain in mid-December. And those really try to focus on clarifying some of the processes and safeguards that are in existence for protecting personal data in the context of certain types of access, like for law enforcement or national security. So there's various different sort of lenses in which we look at data localization specifically, since I know that's at least the underlying premise of the topic, of the panel. To your question about the bill, I think we're, in particular, my colleagues have already said all of the interesting things about the bill, but we're very interested in understanding more about the whitelisting provisions, in particular from the vantage point of the OECD, how that works with other regimes. So sort of the multilateral or other unilateral regimes. So we're, from our vantage point, we're most interested in the international component of things and how we get harmonization or interoperability between different systems. So interested to hear how the whitelisting will work and how that relates to other regimes like adequacy or CBPRs or otherwise. So, and what's behind the whitelisting. I will also flag, we noticed that, quite a focus on consent, and I think others have mentioned the limitations of consent already, and so some further thinking about potentially a bit of an over-reliance on consent or how that will play out in practice. But I think just commend your efforts to move legislation along. As was said, it's important to have sort of your national house in order and the national data protection regime, and I think it benefits a lot, as you can tell from just the reading of the bill, from many of the international instruments that exist out there. I think in terms of cross-border data flows and data transfers, I think at least from the OECD's perspective, we're very interested in keeping data flowing reasonably while protecting it at the same time. We don't see them as inherently against each other or the mutually exclusive concepts, but that we do know that in order for that to be successful, we have to have both strong data protection and privacy that work together across borders, or that are at least have commonalities that can be articulated and are maybe interoperable or converging toward a set of standards that companies can trust. I think, and I'll close on this, some work that we're doing in the concept of data free flow with trust, as we know, also has come out of the G20 over the years, particularly under the leadership of Japan, where the concept of localization or the questions around localization appear most frequently, at least in our work. We have been undertaking a series of empirical studies, working with companies on their experience in data transfers. And I think it's not surprising that what we will find and what the findings will say is that stability and predictability is of the most important for companies. one thing I do worry a bit about is in a whitelisting regime, you can have a lot of predictability in the sense that, it's kind of a blanket. It seems to be, at least based on our initial reading, sort of blanket ability to transfer without much nuance. So it might seem good on the front end because it might provide that sort of sense of stability. But as time goes on, it may be difficult to unpack how those protections work if they're not spelled out, or they don't interrelate with other international efforts to interoperate and to converge around principles for protection, particularly in the transfer of data. So just excited to be working on that report, which I expect sometime early next year to be made available and discussed in both the G7 and the G20. So.
Thank you, Audrey. And let me use that to start talking about whitelisting and what it entails. And Audrey made the point that some part of it entails a degree of interoperability and commonality of privacy standards. So, Rahul, to begin with you, do you think whitelisting is a proxy for adequacy, or is it something different, or is it something in addition to adequacy?
So I just want to first start with the fact that every whitelist has an implicit blacklist. It's a yin and a yang. So I don't think we should be fussed about whether it's a whitelist or a blacklist, because it's just a little harder to figure out if it's a whitelist, because you have to go through a list of 185 countries to find, the 10 that are missing. Or we can just put a list of 10 countries, and then all the other 185 are, I don't know how many countries there are, but you get the idea. So I'm not hung up with the difference between a whitelist or a blacklist, other than it's just an easier thing to do. But to answer your question around adequacy, I think I agree with what Audrey says. A whitelist is very different from adequacy. A whitelist is a list of countries to whom data transfers are permitted. It is not a process by which you stipulate, as Europe does, that you can only transfer to countries that are adequate, and then we will go through a process to figure out whether you're adequate or not, and then you can go. In that sense, it is, forgive the reiteration, black and white. You have a list that you can transfer to ab initio, or you don't. I think the point that Ralf and Audrey make are actually important to engage with, which is that the reason why Europe does this is such that its citizens or residents can enjoy the same level of protection that they're used to in their home jurisdiction if that data happens to be transferred out of the home jurisdiction, which I think is certainly laudable. And I think we've all around the world got to find ways in which we can achieve that. But I think we all got to recognize that is, as we are seeing with Schrems 1 and Schrems 2, extraordinarily difficult, because it comes up against the point that you mentioned, which is the sovereign expectation of a nation state to be able to do what it will, what it wants with the data that either pertains to its citizens abroad or its organizations within. And this is a thorny problem, and I don't think it's a problem that a whitelist or a blacklist or an adequacy or BCRs or SCCs or any of the other, or CBPR or DFFT or all the other acronym alphabet soup that we've been dealing with for the last 10 years will ever adequately solve. But that doesn't mean we shouldn't keep trying. And I think some of the work that OECD is doing to come up with principles, and I think it's good to see both Ralf and Audrey recognize that some, if not all, the principles are reflected in this draft, is an indication of how we should go about this, which is, India currently has 0 because we don't have a law. If we can have a law with a large number, or at least some of the principles reflected, we're moving a step up, and the rest of the world is also sort of defining these things till it becomes actually de facto adequate to transfer it to all countries that follow the same or similar principles. And I think just to as you probably realized, if we had started this panel at breakfast, it would have been a much fuller panel because we've already discussed a lot of these things, and I don't want to rehash them. I think it is extraordinarily important to recognize where India is, and perhaps people who are not in India are assuming India to be higher up the chain in data protection than it actually is, with good reason, because we've got very sophisticated techno-legal solutions that we've spoken about throughout this conference, digital public infrastructure, etc. But the actual practice of data protection in India is at ground zero. And we've got to allow India to build its internal mechanism before we can expect it to be at the gold standard that Europe is at after 30 years of doing this. And I think we have to allow ourselves the time to do that. If we don't, we are going to mess this whole thing up and be in an even worse situation than we are right now.
Melinda, let me turn to you next. So 2 questions. One, do you concur with Rahul's assessment? The second is, does a whitelist, blacklist, whatever it is, does it actually solve law enforcement concerns about getting quicker access to data, easier access to data? How is that going to play out if we go with this kind of an approach?
So I agree with what you were saying. I mean, I leave it to you about the assessment of where India is in the progression of data protection law. But I think, I think generally the approach set out in the law is the whitelist, blacklist, is an opportunity for India to determine what it wants that to be. It has lessons to be learned from the EU. It has lessons to be learned from other places. It need not be, a kind of adequacy regime. Indeed, I think, trying to impose that level of review at this stage would be quite cumbersome. I mean, Ralf knows better than anyone how long the adequacy reviews process take. And so I think there are a lot of open questions about what should be reviewed as part of that assessment. You want to make sure you're making kind of apples to apples comparisons, and that may be hard if for some countries in the world. And so, I think it's an interesting idea to think about a blacklist approach. Default is that data can flow unless certain criteria are present, in which case it cannot. So I think it's, there's a lot of room here to explore really creative solutions. I also think it's important, if we just step back for 1 second into kind of first principles here, what we're trying to do is protect the data where it flows, and everyone agrees on that. If that's the case, we also need to give tools back to companies to be able to do that themselves, apart from the government's whitelisting or blacklisting. And so in prior versions of the draft, there were other bases for transfer, like intergroup schemes or contractual clauses, which do exist in the EU and which have now been taken out of the draft. And so I think if the goal here is to protect data, then we need to employ all of the tools to do that, particularly because administering the kind of whitelist blacklist regime is going to be a big task. So that said, I think on your question about law enforcement access, I think, again, it depends on what considerations are going to be taken into account as part of the whitelist exercise. Is India going to look at law enforcement access data issues? And so I think that's an open question. I don't think this inherently, I know that concerns about law enforcement access to data were a prime driver of data localization, although, I think has been explored a lot in the last few years. Localization does not solve that problem at all because of the legal regimes that us as a US company have to comply with. It doesn't actually break that deadlock. And so that's why I think the work that Audrey was referencing at the OECD in terms of, coming to a common set of principles around trusted government access to data is incredibly important. And I think the more that we kind of converge in that space as a set of like-minded countries, it is going to chip away at some of those underlying tensions that are driving some of the data localization debate.
Thank you. And Rahul, let me come to you on the same theme, because I think it's something that is an important motivation for why we've been talking about localization. And you made that point in your opening remarks also, that even if you do have this version of the bill, we still have to worry about increasing regulatory requirements in other sectors, RBI, SEBI, IRDA, and so on, who are already insisting on some level of localization, and it may continue creeping. Right? So how do we solve that problem? Does whitelisting guarantee some kind of a panacea, or are there other mechanisms that we need to think about?
No, look, I mean, I think the sectoral regulators are going to have to take their own call as to what they're going to do with that. But I think I'm just hopeful that since the first draft of the data protection law gave the direction to sort of try this data localization, and having had such fulsome discussions, as Melinda says, went through this whole question of whether it improves access or not, and it seems like the government is walking that back. Perhaps that would encourage the RBI to walk it back. I have absolutely no hope that it will, but that's the only thing that we can expect. I don't think it's a panacea. I think what this law says will be with regard to the data that falls within its ambit to regulate. But if the Reserve Bank of India has a higher bar for financial information, then I think that bar, it's the prerogative of the Reserve Bank of India to do what it wants with that data. And I don't see this in any way rescinding the payment localization mandate or perhaps even the e-commerce and the other mandates that are coming out.
Right. Audrey and then Ralf, similar question, but what do you think are some of the other mechanisms that you see used bilaterally, multilaterally, or within the domestic jurisdiction itself that tries to give the level of access to law enforcement authorities to domestic citizen data? What is a good way to ensure this access? Audrey?
So yeah, thanks for the question. I mean, I think there on the maybe separating law enforcement and national security, which we do not do in our work at the OECD. We have them together for various reasons. We have them together, but I think in the law enforcement sphere, there is much more activity and common or efforts and international cooperation in law enforcement at the European level, but also across borders. On the national security side, I think there's much less, at least in terms of international instruments, or maybe nothing. And so in that sense, I think our principles are unique. Also, the scope in which of the countries that they recognize. So it's obviously much of Europe, which is members of the OECD, but also Asia and South America and North America. So we've managed to compare a bit the systems for accessing data under law enforcement and national security laws in a sort of geographically diverse set of democracies, which is unique. And I think the first time you will see something common written about how what the protections are in these cases, which is what we're most interested in. We know that access needs to be sought. Ralf said it. All of our democracies have provisions, including the draft bill in India, for accessing data for the purposes of protecting the state, for the purposes of countering terrorism, for the purposes of enforcing the law. Those all exist, and they are usually carve-outs for general data protection law. They're usually exceptions to certain protections. It's the balancing, or the decisions of balancing rights. And so we know that rights often can need to be balanced, and that in order to infringe on a right, there has to be a justification and various things. So, for example, when the right to privacy is in conflict with the right to security, or the right to the protection of the person, that's the most sort of classic one in the realm of law enforcement and national security. So I think the question of what we're really trying to do is try to set a sort of baseline, to communicate a baseline of how this works today in countries, because it's maybe poorly understood or not easy to communicate. These tend to be complicated laws. It tends to come from a community of people that don't whose primary objective isn't always to work with other countries. Obviously, it's not like the data protection community where there is an imperative of cross-border cooperation. That, for example, is built into the privacy guidelines back from 1980. This idea that regulators would need to cooperate across borders in order for data to flow. That's less of an instinct in the national security and law enforcement communities, although perhaps a little more in law enforcement, because that's in order to enforce, in order to combat crime, there's obviously some cooperation that needs to happen. But so for what we're trying to do is to articulate how democracies deal with these protections, how they put them in place, and how they're executed, and in order to, I think ultimately be the beginning of a conversation about how they can be first leveraged by a larger set of countries. In the OECD, it's 38 countries, so it's significant, but it's small in terms of actual numbers. But that standard, that baseline doesn't exist. And so I think that we hope that's an important contribution, so that when we look at, should we trust this country, whether it's a whitelist or a blacklist, or whether it's something else. And I'll just take the moment to say that I do think it's it's a very significant question about if you go down this sort of blanket whitelist path and you have sectoral regulations, how you're gonna make those work together. But anyway, the principles on government access intend to sort of set this baseline for the discussion about how our democracies increasingly deal with that set of trade-offs that have to be made when accessing data. I think it was sort of not overtly referred to, but the Cloud Act approach, where a jurisdiction can get access, is another consideration. I think that Melissa mentioned it in her intervention. So these are various moving pieces to try to kind of get at this issue of how these type of authorities access data and how to build trust in that, which is ultimately what we're trying to do. We're trying to allow data to flow and trying to look for reasons to trust another place, another jurisdiction, another country's system. And in order to trust, you have to understand. And in order to understand, you have to have some amount of communication and transparency. And so, ultimately, this is the first step, at least in that domain, from our side in the OECD.
Thank you, Audrey. And before I turn to Ralf for a last comment, we have about 5 minutes left. So if anyone has questions, please come to the mics while Ralf gives us a response. And I think we'll be able to take a couple of questions at the end. Ralf, quick couple of minutes if you want to come in on the same question.
Yeah. Maybe just 3 points. One, to come back one last time on whitelist versus blacklist. I see Raul's point in terms of once the full list is established, maybe the difference between a white and a blacklist isn't so different. But on the way there, I think it's a huge difference, because if you have a whitelist approach, transfers are prohibited until you're whitelisted, and then it depends on how quickly this goes. It's different for a blacklist. So I think there is a difference, certainly in terms of timing, and I think Melinda's right. That then links to the standard that you apply. Indeed, it takes some time if the approach is to assess a third country's data protection regime and possibly beyond. It indeed takes some time if you do this thoroughly. So that's maybe the first point. If it's a blacklist, so if you basically just want to, I'm saying just, but if you want to indicate which are sort of unsafe destinations, which is something, one can certainly consider. But then I still come back to my question. So what for all the other countries that are then sort of indirectly or implicitly whitelisted? What are the safeguards that apply for these transfers? And I think I share Melinda's point on what about other transfer tools? Why are they not considered? And I don't think they necessarily have to be complicated or something that a country like India couldn't apply. I mean, if in particular I think about model contracts, model data protection contracts, which is something which ASEAN has now developed and which the Latin American data protection authorities have developed for the entire region, and which is just being picked up by Brazil now and Argentina, and which we have developed, and the UK and New Zealand. So I think it is a tool that can be used, and the beauty of it is they are pre-approved. It's a model contract, which in particular small and medium-sized companies can easily use because they just download it from the internet, fill in the annex, and that's that. Of course, there's compliance, but I don't think if it's sort of aligned with the standards that you have in India, then I don't see why that would be any problem. So that's maybe the second point. And the third one, I mean, Audrey has spoken a lot about the OECD government access principles. We have shared, 2 years work on this with a number of other countries. So I can only underline, I think, the importance of this document. I think it's really an achievement. It was not easy, but at the same time, I must say I'm quite surprised in a way, and positively surprised that it was possible to find common ground. Audrey said the OECD is small, but I mean, it's not that small. It's still a large group of countries that came together from across the globe. Including many from the Asian region. And yet it was possible to find a good set of principles which is sufficiently ambitious and still workable. So I think that's certainly for the future something that we can build on. And when it comes to law enforcement, I mean, I have done this before in an Indian context. I never receive a lot of enthusiastic response on that, but there is the Cybercrime Convention, which I think is a super important instrument for law enforcement cooperation across border, including with the second additional protocol, direct access to companies in another jurisdiction. So I think that is something, there is a multilateral way forward. Again, this was not an easy negotiation. I've also participated in that. There's a whole data protection provision in that second additional protocol. So also that was possible at multilateral level for an area which many countries, for them it's new to have data protection rules in the area of criminal law enforcement, but it was possible. So I think we should not despair. There's ways. You don't have to do this unilaterally, and I think indeed multilateralism is the way forward on these issues.
Thanks, Ralf. We are literally at the last 20 seconds, so one very quick, short question from there.
Yeah, I'm audible?
Yeah.
So, good morning, one and all present here. My name is Mayank Gupta, and I am a young ambassador, a representative of Kautilya School of Public Policy. So I just wanted to know, with respect to the DPDP bill, we see that the central government has the authority from rule setting for qualifying significant data fiduciaries, as well as determining jurisdictions for cross-border flow of data, which we have discussed in detail. But don't you think that this approach of the government being a dominant force in this legislation will lead to arbitrariness, and what could be the role of the data protection board, which has been mentioned in this bill with respect to cross-border flow of data?
Rahul, quick response.
So I think so there's been a lot of talk about the extent to which things have been left for later. And I have, for a long time, held the view that for a technology regulation, the only way to go, literally the only way to go, is to prescribe principle-based regulation and allow for agile governance after the principles are clearly articulated, largely because, as we've seen with GDPR and we've seen with various other laws that are perhaps GDPR is principle-based as well, but it comes up against the fact that new technologies make it impossible to navigate regulation when the regulations are too hard-coded based on existing law. And so I'm actually quite in favor of having principles and then allowing for subsequent regulation. We've got to get it right. We can't allow this to violate the principles of excessive subordinate legislation and inappropriate delegation of authority from the legislature to the executive. That's a line that we've got to very, very clearly stay on the right side of. But I think when it comes to technology regulation, there is literally no other way to go. As far as cross-border is concerned, I think, just to make it very clear, the reason why I don't think we have SCCs and BCRs and model contract clauses and all of those things is because my understanding of the way of the government's approach right now is a blacklist or a whitelist, but whatever the list is at that point in time, it is the list. So if you are not yet on the whitelist, that means you are on the blacklist. And so in all those cases, I think the government's saying that yes, data will not be allowed to transfer to those countries, not through a BCC, not a BCR, not through an SCC, not through anything else. And so my sense of how this is going to work, and I'm not sitting, in the government seat, is that that's why I think we're going to have to start with a short list of countries to which data will not be allowed to be transferred. That whether we do it by exclusion or inclusion will determine whether it's a blacklist or a whitelist. And then for everything else, data will be allowed to freely transfer, which is why we don't need to worry about having SECs or BCRs, because you only have SECs and BCRs when there are some restrictions on transfer. That's the way I think, just reading the tea leaves, this is going to end up. But you can call me next year for Carnegie and prove me wrong.
Thank you, Rahul. A great note to end the discussion on, very constructive. And I must thank all the panelists for a really engaging discussion. Thank you.